Every trial attorney is confronted with the issue of motions in limine. Whether the attorney is making the motions or going to respond to a pile of motions filed by his opponent. It's an important prospect when you're approaching trial that you have to consider, number one, what do I want to accomplish with a motion in limine? And number two, what is the other side trying to accomplish? I'd like to make a few suggestions to you as to why you should consider using motions in limine and how to prepare them as a second issue. The reason you should consider using motions in limine is that I find them far more effective than a trial brief in presenting the important issues to the judge. Judges look at them differently than a trial brief because what you are doing is presenting an issue of evidence, and you have to give context in which that evidence arises, which allows you to tell a better story than simply the one that you tell in your trial brief. I have to warn you that many judges look at motions in limine as a waste of time, either because they are usually so overblown and overreaching that they don't feel that they're of much use, or the judge is so burdened with a pile of them that he sees it only as a task and how quickly can I get through this before I can start my trial. So there is this tension, pushing and pulling of yes and no on the question of whether you should use them. My approach to motions in limine, and one that I suggest that you consider, I lay out every piece of bad evidence that the other side has, and every bad aspect of my client's story and of my client. I sit down and make an actual list. And then I consider, is this something that is going to get into evidence, either as impeachment or as an aspect of the case or part of the story? I need to figure out where these bad pieces fit. When I've decided that I'm going to file a motion in limine, from the list that I've prepared and after performing my analysis, the next thing that I do is I sit down and I write the order that I'd like the judge to enter. Because the first thing that I do in my motions in limine is I have a heading before I even introduce the issue, requested order. And then I put the order that I have already drafted. What I do then is I detail the evidentiary context in which the piece of evidence or bad fact arises. You cannot make a motion in limine like only relevant evidence will be admitted, or exclude all hearsay, or limiting the other side's arguments. Those types of motions show that you are a rookie. You need specifically detailed, evidentially directed motions in limine that are dealing with one piece of issue, or one piece of evidence, or one issue. Preparing the order first focuses you. Then you talk about the evidentiary context. Then you talk about the prejudice. Now some people, and I happen to agree with this one, they have the order, they do prejudice if the evidence comes in, and then they talk about the evidentiary context. I like that order better because what you really need to show the judge is that the prejudicial impact of the evidence is going to be far outweighed by its probative value. If you're laying out the prejudice first, as the judge is then reviewing your detailing of the evidentiary context, you're going to be much more successful because he already understands what you think the prejudice is. You want to be honest, you want to be detailed, you want to be fact-specific in these motions. If you do that, you'll accomplish a couple things. Number one, you'll educate the judge. Number two, you will send a message to the judge that you know what you're doing. And number three, out of all of the motions you file, you may get a couple of them granted, and then you've staged your case for its best possible presentation. When the judge rules on the motions in limine, if he rules against you, for example, on one that you think is very important and you've asked for exclusion of evidence and he declines, make sure that you make your record that it is without prejudice and that you can revisit that issue at the time that the evidence comes up. And you may ask a subsidiary question of the judge on this. If he agrees to your first, may I have an order that until the court determines that this is admissible, that counsel not mention it in opening statement. then you've got the benefit of eliminating it from the other side, even though the judge has not ruled that he's going to exclude the evidence from trial. Look at motions in limine, be succinct, be direct, be as short as you can, do everything you can to ease the judge's burden while making his decision-making task easier, and you will find great success in motions in limine. This is Steve Young, YoungOnTrials.com and MasteringTheCourtroom.com, where I'm giving a seminar or a series of webinars that talk about how to go to trial based on my 35 years of experience and almost 200 civil jury trials. Thank you for watching.